Good morning, everybody. Welcome to the Cannabis Legal Group. This is Craig Aronoff along with Nick Galendez. We're here to bring you Cannabusiness live as we do every Friday morning. Hopefully you can hear us okay. If there's any comment as far as our sound, please let us know during the show so we can make adjustments. From our gathering, it looks like it's working pretty well, so we'll look forward to a good chat today. Nick and I are going to be going over, there's the two of the largest cities in the state of Michigan, Detroit and Grand Rapids, had progress this week, which is always a good thing, and we're hopeful that that progress will kind of translate into some very, successful cities as far as the marijuana business and, the medical market here in Michigan. As we were kind of wading in and getting ready for the show today, it's really amazing to see the differences of how certain cities approach this. We'll do our best to kind of talk about it at a level that makes sense and certainly answer as many questions as we can, but there's definitely going to be some, things deeper in the mud that time is going to allow us to better understand, because this stuff in Grand Rapids is very fresh. Detroit is actually not quite there, but we want to talk about the progress they made. Certainly throughout the show, like us, share us, ask questions. We'll do our best to address the questions live during the show, as we always do, and we'll look forward to the engagement on that. And so why don't we just take a step back, and Nick and I, what I'd like you to do is just, you're a pretty good historian of the city of Detroit and all of that. And I think it might be best to start with at least kind of a summary of, where Detroit is and how we got to this point. And so why don't I take you back in the Wayback Machine, and why don't you tell us a little bit about, how the MMCC came about, and, take a minute or two and tell us so those that aren't as familiar can kind of catch up with that.
Sure. So as you know, in 2008, the Medical Marijuana Act passed, allowing patients and caregivers to be a part of this framework. I think shortly after that, there were facilities and places in Detroit that wanted to serve their patients either in accordance with the Act. The holes in the 2008 Act allowed certain municipalities, such as Detroit, to authorize these in one way, shape, or form. Either by giving them, zoning compliance for retail or medical office sales. Kind of fast forwarding a little bit, places started popping up around the city. It was identified by the city as being an issue that they needed to control. So in October 2015, they passed the MMCC Medical Marijuana Caregiver Center Ordinance.
Why don't I stop you there for a second? I know we're going to talk a little bit more about it, but the caregiver ordinance, it was stores intended, was grows intended, they call them all caregiver centers. So how do they distinguish between them?
Well, the application process in the ordinance allowed for both provisioning and also cultivation under the Act. And as we've seen, just kind of jumping on a tangent, the recent court case, DeRuiter versus Byron Township, definitely kind of confirmed what I think a lot of us attorneys were arguing, that caregiver conduct under the 2008 law is very protected.
That's right. And for those that didn't miss our show last week, Travis and I did talk about the DeRuiter case in extensive detail, but that kind of rolls into why Detroit was doing what it was doing in trying to put some constraints on the commercialization of the marijuana industry, correct?
Yeah.
Okay.
Yeah.
So, I'm sorry.
Oh, no. Yeah. So there's a lot of uncertainty with, municipal power and ability to regulate caregiver conduct, but the city of Detroit had allowed its own licensing framework because they were, I think more or less, the state was still kind of jumping on board with the MMFLA. They wanted to have some control, and instead of, allowing the proliferation of, over 150, 200 or some facilities in the city of Detroit. So they passed the MMCC ordinance, came into effect in March 2016, and then they started going through the application process, which was very up and down for the city. I think they, went through approvals. They went through a lot of appeals. There was a lot of litigation going on. And then the state passed the MMFLA.
And just so people are aware, the Detroit had within its buffers 1,000 foot from schools, 1,000 foot from churches,
arcades, centers,
and
parks,
liquor stores. And they also utilized the the zoning board of appeals, the ZBA process, to seek variances. So if you were say 750 feet away from a liquor store, is it possible to maybe get a variance from the city to allow that conditional use to be approved? throughout that timetable that happened within the city, it's not an unfair statement to say it's effectively the way in the way I describe it. Because a lot of people ask, well, aren't there dispensaries? I thought they're already legal. As we're talking about licensing, there's a lot of confusion to those that aren't paying as much attention. My analogy has been, imagine if the city of Detroit gave 13-year-olds driver's permits. It doesn't mean that Wayne County accepted them. It doesn't mean that, anybody outside the city would allow that driver. In fact, you could get pulled over by a sheriff in the city of Detroit and it wouldn't be legal. And so just because the city authorizes conduct with these permits doesn't necessarily mean the state agreed with them. Mm. Isn't that true? And so we saw a lot of enforcement actions and a lot of confusion. People thought they're authorized, but the state and the county were not on board with that. The MMFLA fixed that, and so Detroit had an unusual way to come about their MMFLA process. We're still in the middle of it, just to be clear, but what happened with that? Mm-hmm.
Well, I think a citizens group, they got ballot initiative signatures, and they prepared a very basic opt-in ordinance that allowed for zoning and an application process. They ended up getting that on the ballot in November, and that was approved, which quickly followed then a lawsuit challenging the merits and the ability of that. And I think we've talked about that on a few of our other Facebook
Yeah, we've
videos.
talked about it in the past, but a quick summary of that is simply that, there was two ballot initiatives. One of them that dealt with the opting in and allowing the uses. The second one was a zoning ordinance that would allow where the uses would be allowed or permitted, and it changed the buffers dramatically from the original intent on the MMCC ordinance. And so, the court found that the zoning requirement under Michigan Zoning Enabling Act was something that was really left to the politicians of the city, not to the citizens. On the other hand, the first ordinance was passed. So just so we're all clear, Detroit opted in on that ballot. Then they had a moratorium, trying to figure out how to set the zoning and the application period and all of that. And that's where we had some progress yesterday. The Planning and Economic Development Committee, which is made up of several of the council members, held a meeting yesterday that was about 4 hours long. So it was a deep dive into the mud. And what has occurred is that the city is now looking at keeping some of the buffers that were there before. So yes, 1,000 feet from churches, yes, 1,000 feet from schools, yes, 1,000 feet from liquor stores, just as before, but they've also now have new uses. Instead of all being caregiver centers, they're going to be the 5 license types, and they're all being treated a little bit differently by giving them different zoning designations. Can you be in the M districts versus the B districts and whatnot? Yesterday, what they did was they worked on an amendment that would allow growers who are in the M districts to limit their space to 30,000 square feet of cultivation space on up to 3 acres of property, or 30,000 square feet within a 50,000 square foot building on up to 5 acres. So there is an intent for them to not allow these massive, complexes to be grown here in the city. And so that is a bit of a different twist than I think what people expected, that maybe the city would embrace, huge cultivation centers. And to the contrary, they kind of backed that down and said, we'd rather see slightly smaller operations and leave these big contiguous lands to others.
And how do you feel about that? I mean, I think that, each community has its own different needs and plan for the future. The city of Detroit's going to want more development. And it's no kind of, not a harping against the medical marijuana industry or even the adult use industry in the future, but I think they're definitely taking into account, just their master plan and in the future and how they want, other businesses and just the whole community and city to kind of, reinvigorate itself. And so they kind of take that into account. It's not that they're saying, oh, we just want these many facilities because we want to, we have a, negative feeling against the owners. It's just kind of more how this fits into their whole bigger picture.
I think that's very true. I mean, first of all, let's not forget that the whole MMCC experiment that, had storefronts popping up all over the place, that had grow facilities that, were questionably compliant under the caregiver laws in terms of having maybe too many plants or too many people or too much product being produced. And so the city itself had started with a bad taste. So leaving that as part of the framework of this, I agree. I think that what we don't know, and we've seen a very successful turnaround to the downtown area. So the DDA area in Detroit, we all have heard about all the stories in Gilbert and everything that they're doing down there. But the outlying area is still struggling. And so we're seeing moves like Ford buying the train station. That's a big start. That's a big company coming in. But what's next? Maybe they're looking to move a factory there, and they need contiguous space. So the city's master plan is not about marijuana. The city's master plan, this is a sliver of it. And so recognizing that it's simply a sliver of it, and their intended uses are not to allow these big complexes, really what they're trying to do is maybe find those warehouse spaces or those old industrial lots that still have uses around them and aren't kind of left out in the middle of nowhere. And leave those to those bigger plays. And so corporate counsel Lawrence Garcia was at the meeting yesterday and speaking and testifying before the council that there is a bigger master plan and that they are really interested in saying, listen, if you want that big 100,000 square foot building and 10 Class C licenses and a process license, there's other places in the state to go do that. That was very frank. So I can't fault them for being very frank about it. Hopefully what happens, though, is those people that have made the investments, and expected that there's some nuance or an opportunity for them to maybe bifurcate a building and use it as two separate licenses or however it might work. But time will tell. And so we've seen just a couple of, again, minutia of amendments to it yesterday. It'll be before council on Tuesday. The final draft of that ordinance that will be before council should be on the agenda, so look for that come next week. And, hopefully we'll see Detroit start to move and maybe start looking at that application process later in the fall. Idea being if they adopt it, in the August meeting, probably, 30 or 60 days later is when they'll have the effective date and start taking applications. And that's a great transition to Grand Rapids because when are they starting to take applications?
November 1st.
All right. So last Tuesday they opted in and took I think they opted in a little while ago, but they created their amended ordinance. And I think they're calling it a hybrid ordinance because, quite frankly, Grand Rapids did a nice job contemplating how the rec market might play into their decision making. And they created the ordinance on Tuesday, and they said, all right, this will start come November 1st. So to think Detroit won't do something different is a little naive. I think we can expect there to be some kind of period of time before the applications run. But getting into Grand Rapids now, because I think if we were talking last year this time, all of us in the industry were like, Grand Rapids is a big fat red. They're not going anywhere anytime soon. And quite frankly, that held up pretty true. Very conservative area of the state. For those of you watching who don't know the state and the makeup of its politics, Grand Rapids is the conservative center of the state of Michigan.
But I think a good takeaway from this is that just because a community opts out, and I think we've always said this, doesn't mean they're against it, doesn't mean they hate it, doesn't mean they're always anti-marijuana. In some cases, maybe, and they might make that clear, and they are within that right as city officials too.
Yeah.
But a lot of the time, they want to either wait, they want to really say no, so that they can, they can tie up their phone lines or free up their phone lines, and then really take an educated and thorough look at what they really want to do with it versus jumping into it or jumping out of it completely. So they're definitely keeping an open mind.
I fully agree, and I think that in talking privately with a number of supervisors whose communities had opted out. What had happened is that many said, listen, let's just opt out and quiet our phones, and then we'll figure this out behind the scenes. And then we've seen a few of those communities come online slowly. This is something, Jamie, you pointed out the business community wants in Grand Rapids. And by the way, for anyone who doesn't know, Jamie was very integral in getting this done, and we congratulate her in her effort.
Thanks for all you do.
But seeing that happen and following what the business community wanted and the taxation, revenue, and all the upside that this community has to offer, and now taking buildings that were not otherwise used and bringing them and creating life in places that were otherwise, on the vine. And so this is going to be great for a lot of different things, as it relates. And I think, and I see there's some comments talking about different counties and different places. Truth be told, as big cities like Grand Rapids come alive and the reefer madness of that proves out that there isn't all the scare, that will have a ripple effect. I think we've seen that in the trends throughout other states that have done that. As more communities really pay attention to Bangor and Bay City, for instance, that have opted in a long time ago and have had operating entities now without the criminality that everyone expected, without the nuisance that
Sky
everyone
doesn't
expected. It hasn't fallen. The Bay is still there. It's okay. Things are all right. And so, with that in mind, maybe Saginaw next door will kind of reconsider its position and everything. And so, and I think, and Brad, you just pointed out that a lot of prospective applicants are, maybe trying too forcefully, and I'm going to put that up on there because, Brad, I think you made a good point. For those of us in the industry, it's a matter of keeping in mind these are the places we plan to do business. And that being said, quite frankly, you got to develop that relationship. That relationship is going to go a long way. You got to teach them who you are and talk to them and play the long game, not the short game. Because sometimes being too forced, and we saw that in some southern communities where it was really pushed and pushed and pushed to the point where they weren't ready and just said, all right, fine, we opt out. That's that, and hopefully they'll revisit those decisions. But circling back now to our Grand Rapids, what's great is we have 53 provisioning centers approved. There's quite, I think the number was somewhere in the 80 range, or was that for the other facilities?
Yeah, and so, for those of you watching, feel free to correct any of us if we're wrong, who were there and actually, integral to the process. We've been definitely keeping an eye on it. There were two different plans that were proposed. One of them was a lot more lax and would have allowed, hundreds of facility locations, I think somewhere between, almost 300. And there was the other proposal that would allow 41. And I think what happened with this after it was reviewed and public comment was heard was that they kind of met in the middle, 53 provisioning centers, potentially 83 locations where these will be allowed. They have a lot of distance requirements in there, and I know a lot of those were tweaked at the very end, but I think they kind of, like I said, met in the middle, and I think the ordinance is very well thought out. It's got a lot of interesting things in it, including the hybrid model that we're going to discuss a little bit later.
Yeah, and I appreciate you guys saying that we're spot on and all that. By the way, Barton jumped in there and said, "Nice job, Jamie." We should all say happy birthday to Barton.
Happy birthday, Barton.
So happy birthday, Barton. I hope you have a great day and things are going well in the conference in California, and I'm sure he and Travis will be providing an update and giving everybody a lot of information on what happened at the NCIA event, because a lot of great stuff is coming to Michigan, and they're a part of it. So going back into the ordinance now, a couple things that are standard that we'll see across the board with a lot of communities are these buffers. So 1,000 feet from child care centers, public and private schools, K to 12, no surprises. 1,000 feet from publicly owned parks and playgrounds, 1,000 feet from churches, 1,000 feet from substance abuse disorder centers. 1,000 feet from residential zone districts is measured along the primary street frontage, so right angles, and then 2,000 feet from another location. So they are spreading out the facilities, and that's for provisioning centers, so the storefronts aren't going to be everywhere. I think that one of the other things that this ordinance does is it really has neighborhood engagement and development, and we'll get into a little bit more, but that's all part of this too. I think one of the unique things about this ordinance that's different than other places is, of course, that, you can work with the community to maybe get them to agree to changes in that buffer. And so there's some language in the ordinance that does allow for you to go back in and maybe get approval of those that have, that's not to say you can necessarily get the school to agree, but the park and the community around it, the residential districts, if you have something that is a solid program and you've engaged the community, Grand Rapids is leaving the wiggle room to say, then yeah, if they want it, we'll allow it to happen. And so I think that's an important change that we're not seeing in other places.
I think another important and unique aspect about this ordinance is that they're kind of realizing that different licenses have different needs as far as application processes and changing potential aspects of your plan. I know, some of them do require the traditional special land use hearing, but if you're a grower and you want to change from A to B or B to C, or you want to stack licenses, that kind of, I don't want to say expedited, but it goes through a different review process. So instead of having the same land use hearing just to add another Class C license, you'd be able to submit it to the director. I can't remember from what department, but I'd assume the building director or some high-up official there who would have to review that change and kind of streamline the process there. So they're definitely, instead of having zoning ordinance restrictions and criteria apply across the board to these different unique types of facility types, they're acknowledging that there are these differences and making that a little bit easier on the application side of things.
Well, yeah, certainly, and I think that's actually a credit again to the work that was done in preparing this and comparing other communities and looking at how some backlog occurred or some bottlenecking occurred. Once you're zone compliant, you should be available to continue to keep that zone and maybe transfer it without having to have everybody go to the back of the line and start over. And so there were some good sides to that, and certainly if you're making a substantial change to the building, then maybe you go through the same special land use requirements that you would, if you're just planning any major construction on a commercial building. Most of those have to go through some process to get approval for the plan. You don't have the unlimited right to do anything with what you want on your land in Michigan. So that's certainly part of it. But if you're making a minor change and it's just less than 20%, for instance, of the size of the square footage, you go to the director and that person reviews it and says that's good. And we don't necessarily need to go through all the hoopla. And so I think that's actually a portion of this ordinance that's different than a lot of other communities that, quite frankly, they should consider and take on because it will reduce their workload and make their lives easier. Now, where it might change is the fees, of course, because they get paid to do those hearings. So there is a little bit of that. But nonetheless, they do build in these other areas for neighborhood development and for the quote-unquote voluntary economic development. I'm going to talk about that for a second.
So
the word voluntary is
in
here as a requirement.
For as intricate and well thought out as this ordinance is, it does require a substantial amount of materials in the application from each applicant. You're going to need to submit your step one and show proof that you've submitted it to the state, but it also requires that you also include all of the materials that you've given to the state for step one. And even thinking down the line, they're going to want the renewal application, the materials in connection with any investigation. They're going to want your step two facility plan and security plan. They're going to want a crime prevention plan through the environmental design of your facility, operations and management plan, and a good neighbor plan, which is definitely very interesting and unique, I think, as far as requirements go. We can kind of talk about that very shortly.
Sure. I mean, and I think, again, that, as we look at those, it's really making you stop and think, like, how can I best contribute to the area I plan to be? How can I contribute to the community I plan to operate in? A lot of our clients, a lot of operators that we've seen in other communities go in there and they're pitching the idea, we're going to be great partners. We're going to be, making all these promises of this, I'll give you 1% of our total revenue or some crazy things like that people have come up with. And this is saying, put it in writing and prove it. And then go talk to people and prove it. Another odd thing, I think, which was very interesting is that they require the application itself that's filed with the state of Michigan. So a pre-qualification is a requirement for a provision center. But then they go on to say that they actually want your phase two narratives. In other words, they want to see your security plan. They want to see your facility plan. But if you're investing in a building that you haven't actually done that work on yet, and you just want to know your zone correctly, they're making you maybe consider spending the money on the architect and the work to be done in order to establish that your plan is better than the next guy's. So there will be some consideration as to those that are applying really needing to know their long game and demonstrating that and taking the time to learn it. You have till November 1st. So now's the time, if you have a property locked up, go talk to neighbors, go get to know the area, go figure out where the pain is in the area, go figure out where your best contribution is. Money might not be the answer. It might be actually cleaning the streets. It might be, offering water or food, and things like that are different than what people might anticipate as just, if I put money into a fund, that's all I have to do. What's a fund doing? That's not enough. So I think we're going to start to see that. And again, Grand Rapids' model of this is unique and may provide something that other communities should consider. Maybe not all of it, because there's a few things that I don't like for instance, the facility plan having to be up front. But again, they're making you dot your I and cross your T, and not just saying just because you're zoned correctly means we're going to say yes. Mm-hmm. It's prove you deserve a license.
Yeah, and I think in more competitive markets too, we've seen this. Not that they're just doing it for the sake of knowing that it's going to be competitive, but they really want to know, if there are going to be a lot of applicants, which ones are going to, rise to the top, which ones are going to provide all of those facility plans and floor plans and site plans that really blow the municipality away with, okay, we trust these operators. They really have everything together and necessary to be established, but also to thrive based on what they've provided to us. And sometimes that might require a leap of faith with having all of your narratives presented and a step one in prior to even knowing if that location works, if that's what it takes to be in a competitive market and the second largest city in Michigan. So
yeah, I mean, you got to do what you got to do. And there were a couple of comments here about, millionaires only, or, I think there was another, Scott, you were mentioning how you're worried about, your caregiver grow and stuff like that. So, again, the MMFLA requires capitalization. There's no question about it, but not millionaires. I mean, again, it's $300,000 capitalization for a provision center, and that money is to be used to build your store possibly. And so, while I'm going to not poo-poo the idea that you need substantial capital, there is a micro business actually contemplated in this ordinance for the presumption that the rec bill will pass. Mm-hmm. So that business is something that is intended to give caregivers in the future an entry into the marketplace that is different than what the MMFLA was creating. Certainly between now and the bridge of time when we have fully licensed facilities all throughout the state, caregivers are the backbone of everything that we're doing. And, you got to stay compliant. The rules still apply. And, 72 plants if you have 5 patients and you're a patient yourself, and you can't have more than 2.5 usable ounces of marijuana. We did see some case law talking about what usable marijuana is. And so just pay attention to the rules and stay within it and treat your patients, and you'll be fine. And so it's those that are pushing the envelope that are finding themselves running into problems. But in the meantime, caregivers are needed for every grower and processor in the state. There's great positions to be had. There's great ways to use that talent and bring it to operators, both in the MMFLA and who will be doing rec in the future. So don't get discouraged by it. Find your niche and leverage that, because that talent is valuable to a lot of these businesses that will be seeking licensure.
Mm-hmm. So before we kind of move on to the hybrid, topic on here, as far as the good neighborhood plan goes, I mean, I think it's great that it's in the ordinance. They want to see this from their applicants, and it actually requires you to prepare a record of good faith, they call it, where you send notices to the neighborhood and meet with local adjacent businesses. You have to basically provide to the city in your application that notice, who you met with, the times you met,
prove it,
copies of the draft of the plan. So it actually really requires community engagement. But the thing is that I think as any business looking to enter in a community, you should want to do this anyway. You should, maybe not as far as record keeping goes, but you certainly always want to reach out to the adjacent properties and the local bigger communities in the municipality to get on board with them, to show that you're a team player, to show that you start those working relationships with them now, to show that you're actually here to stay, that you're a good neighbor, and that you can actually, there's nothing to fear from you being in there, and you're not a bad marijuana operator looking to just turn the whole city green. You actually want to engage in things with the community.
I can tell you just from my experience in working with some operators through the Detroit process and everything, that community engagement it goes so far. I mean, once they actually get to know who you are, and they see your facility and they see the security of your facility, if you want to bring in the neighborhood president, I encourage people to go to the community, meeting themselves, introduce themselves, tell people what you want to do, be transparent. That transparency is really the key to showing you're authentic and that you're real, and that this is what your real play is, and that that's the opportunity to do that. And again, letting them see the security and understanding that it's not just the building itself that's going to be secure. The perimeter around it is actually going to increase. These facilities are vaults. I mean, they're safe. There's people that tried to break into one last week in Detroit, and the video, like literally from the moment they got in the facility and were running around, the police had to were outside the facility waiting for them by the time they came out. But most importantly, they got nothing. Mm-hmm. Why? Because there's nothing available. It's all in the vault. I mean, crime in these facilities is not going to be a long-term issue, and so it's proven itself out in other communities. But again, meeting you and understanding that you understand those things and that you're going to be implementing that is key to the neighborhood being more comfortable with you. And I think that's a great start with all of that. There were a couple other questions that just talk about, I think this is eligibility question in terms of talking about a felony from 20 years ago. Again, the law says if your felony is greater than 10 years, you're not ineligible. The question then becomes is what may they review that could cause them to question that eligibility? So what have you done in the 20 years since? What is the good that you've done? You got to lay all that out and show the state the quality of person you've turned into despite the hiccup you may have had in the past. And just because, people have that doesn't mean they can't be employed at a facility. If you got your caregiver card, that was enough through Laura to say the felony wasn't prohibitive on that. And so I think that's very helpful. And Brad, you're doing a nice job helping with the extra resources. That's always appreciated. And we always appreciate your watching in and participating in it as well. I think we do our best to keep our shows at a half hour. We've talked quite a bit about a lot of different things. You mentioned the hybrid law. Why don't we just talk a little bit about that part of the ordinance? Because I think, again, what Grand Rapids did was they said, all right, this is for now, but we've already thought about how this will affect the future. And I expect Detroit, actually, talking with the law department and the corporate counsel, they're kind of doing the same thing. So tell us a little bit about that.
So with the adult use recreational ballot initiative in November, I think this isn't something that all municipalities need to necessarily do, but I think it's very forward-thinking for those who actually put together something like this. From what I understand, the city of Grand Rapids was concerned, if we open up the floodgates now and everyone comes in, are those small businesses, are those Michigan residents going to get shut out from the market based on either our zoning requirements or things down the line, capitalization, and so on and so forth? So what they did was they're anticipating the adult use ballot passing, and they're saying, okay, we want micro businesses, which are 150 plants, process, sell at storefront, can only own one of those licenses, exclusive to Michigan residents for the first few times. They said, okay, we're going to create pockets in our ordinance to allow these to kind of fit in. Ideally, once the medical facilities start falling into place, there's fewer restrictions for these micro businesses. So they also set up an application framework, kind of a timeline for when these micro business applications are going to be accepted. So I think that definitely leaves available property and real estate open for those local small entrepreneurs that want to get in the business in Grand Rapids. I think it streamlines the process for municipalities, at least in Grand Rapids, and those in the future who are thinking of doing this to realize it's polling very well. It's likely, I don't want to knock on wood, but it's very favorable to pass. So what can we do ahead of time? Do some research, look into things, anticipate what's going to happen, and actually have that in our ordinance.
Yeah, and I think again, this is the area where the coalition did a nice job in the ballot initiative. And while people may have criticism of some of the minutia of it, overall they did a really nice job of saying one of the fallacies of the MMFLA is the idea that the little guy is left out. Well, this is the room for the little guy. A Class A license is about a 100-plant license now under the rec bill or whatnot. And then there's the micro businesses, and so there's room for people that are caregivers to grow into being a licensee in both the MMFLA, but certainly in the rec bill. So it might take a little while to get there, but being patient and being skilled at what you're doing and developing your trade and your brand while you're a caregiver and learning your trade, that's all part of it. Just stay compliant. That's the key, because the moment you lack compliance, then you might be boxed out. There's a question on debt through a promissory note. There is on the application within the forms a statement of money lender form, I think is the actual official title. It does allow for people to borrow money for the capitalization. So, but I think just to be clear though, it is not necessarily saying that you can be somebody who's drowning in debt and then borrow more money and still comply. I think that your overall package still plays a role. So even though your capitalization is coming from, the money borrowed, we have to be careful that the rest of your package doesn't, stain it in some way in terms of your own bad credit history or bankruptcies or stuff like that. On the other hand, it's good business to take on debt. A lot of commercial developers use debt as leverage. I mean, we see that all the time. And so there's ways to move forward with it. Just you got to look at the rest of the package to know. You know, and I think that there was another question about out-of-state investors. So I'm going to address that real quick. And no issue with that as long as you're compliant. Right?
Oh, are we talking about adult use or
just we're talking an MMFLA?
Oh yeah, I mean there was, as far as out-of-state investments, I don't think there was any really.
There is no restriction on that. Michigan says that you know, if you're an individual applying for a license, you have to have a 2-year residency, which I think that actually ended, didn't it, in June? Yeah, and so you know there really is no restriction on out-of-state investors to step into this market. You know, again, the key will be is the cleanliness of the money and the package and the rest of it. We're seeing a lot of out-of-state investment coming here, which is great. So if you're not already connected with operators, we have talent that needs money, and we know people that have money that need talent. We're trying to put all that together. It doesn't matter where the money is necessarily coming from out of state, again, as long as it's clean money. And so, you know, I'm trying to keep on answering some questions that come up, but, you know.
I did want to address a question I think somebody asked David up at the beginning about a lot of these municipalities are requiring step 1 pre-approvals, and you know, has Laura addressed the fact that that's allowing a few of those that have gotten pre-approvals to kind of, you know, swallow up all the licenses? I think that, and I think we have talked about this before in other episodes, I don't know that necessarily requiring a full step 1 pre-approval from the state is the best option to go with as a municipality in terms of having your, you know, application criteria for even submitting it. I think there's some issues with that, and okay, you know, you just happen to be a group that, you know, had all of your financials together on December 15th and you went through the process a little bit sooner. How come now you're eligible for, you know, I'm exaggerating here, but hundreds of licenses available and you're the only one of 20 some groups that can do that? I don't know that Laura has necessarily addressed the situation, but I know that they have urged in an interview with Director Brisboe that they weren't really, you know, warm to that idea of requiring step 1. So I know that they're at least aware that it's happening.
Yeah,
but as far as them, you know, gobbling up licenses, I think that's just more of a procedural problem.
I would take it a step further. And first of all, what Brisboe said, Director Brisboe, is that they had no contemplation that this would be a pre-qual requirement for cities and municipalities to do their work. Quite frankly, I think they viewed it as expecting you to be zoned correctly when you're going into the application process and allowing that to be the precondition. But notwithstanding, we do have communities that want to make sure people are eligible and don't have to do the work the state's already doing, and so I can appreciate that position. I might not like it. On the other hand, though, I think as we've talked about the capitalization, and Kathy, thank you for pointing out, your CPA has to attest to it all. So again, how your books balance for this is going to be dependent on how the CPA does their attestation, not compiling it and just taking your word for it, but digging in and knowing all of your finances and signing off on it appropriately. And that was something the board said on July 12th, was CPA attestations and capitalization has been an issue for them, mostly because they're not being done correctly. So,
and they want to see it more specific too, and not just saying, here's what I own, here's my, you know, capitalization. They want those sources and amounts really hammered out, especially when step 2 comes along.
Yeah, and certainly, you know, that is going to play a big role, I think, in how individual operators will do it. But the other thing too is, if we take that out now, when you're pre-qualified and you went in and you said, I'm qualified for a provisioning center license, I have $300,000 in capitalization, that doesn't necessarily mean you have the money to go lock up 7 different properties and all of a sudden you're compliant in 7 different places. You're going to need 300,000 times 7 at some point if that's what you're talking about. And so, you know, just because people got pre-qualified doesn't necessarily mean they have the capital to start locking things up and diluting their capital for phase 2. You know, don't forget, the board members asked the question of the licensing director during the last meeting because they were questioning the capitalization that was in front of them in a pre-qual, and they said, you know, and the question was, well, won't we be able to look at how they're doing phase 2 and see if they're using the money the way they intended and maybe deny them at that point? The answer was yes, right? And so, again, the money says, I have the money to do this, and then phase 2 says, here's what I'm going to do, I'm proving it. So I recognize people might be in an advanced position in the pre-qual, but just because they are doesn't mean everybody's going to have all the capital to do everything they want. Stay true to what you're doing. Don't let that discourage you. Get your pre-qual done yourself. Get in line. And maybe these opportunities by November 1 in Grand Rapids, for instance, it's a lot of time. If your app is pending, it very likely will be approved by that. So let that time develop. Don't get discouraged now on that. And so that's just a few other pieces of advice, I guess, that are out there. And while they've applied and have heard nothing, I think that, what we've seen is the, learning curve from the board, the learning curve from Laura is improving. I'm not, I'm critical of them because I wish they would move faster. I don't like how the board has acted throughout, but it doesn't mean that I can be completely discouraged by what they're doing and saying that there isn't the light here. I mean, they are doing more and more each time. We did see 5-0 votes that took about a minute and a half on the record last time, several of them. So maybe there's 150 more of those that'll go through very quickly. We don't know, and so the better your app is, the key is your app has to be complete, it has to be correct, it has to have all the bells and whistles they want to see in it. If there's something that you should have disclosed that you haven't yet disclosed, don't wait for them to tell you. Supplement it, get it to them. Follow those rules. They're telling you every meeting what they're expecting. Let's just do what they're expecting. So,
and I think with this stringent regulatory and compliance process, I'd rather see them take their time and do it right instead of rush through it and realize they messed up or maybe granted approvals to those very swiftly without actually looking into things, without actually making sure every applicant had their 100% of everything that they needed to have in. So I think it's expected that there's going to be some growing pains. It's expected that things are going to take a little bit longer. Just sheer manpower, sheer volume. It's we're all working our way through the process right now, and it's we're realizing how long it's taking, and for better or for worse, I'd say better.
Right, it is better, and while that board is out there, I think that until licensees are actually granted license, the advisory board's kind of sit still. And the way the statute reads is it required people to be both licensed and citizen groups and all of that. And so time will tell, and that's all we can do, and keep our head down. A year ago, we were excited about where we're headed. We're only a year away, we're not even 7 months into the full licensing yet, or about 7 months. So, in a year from now, we might all look back and say, remember how crazy and long it took, and so on and so forth. And my glass half full view of it will continue that way, and we can be critical without saying we have to throw everything out. So nonetheless, we've taken a lot of your time today. We appreciate all the comments and what everybody's participation is always. Thank you to everybody. Next week we'll be talking, on another topic that's near
something new every week.
Yeah, something new. And as you can see, we're trying to be topical based upon what's happening during the week, and provide that to everybody and answer questions throughout. So if you have anything that we haven't addressed, feel free to reach us at Cannabis Legal Group on Facebook. Go to our website at cannabis-legal-group.com and send us notes there. You can see any prior video on YouTube. So for myself, Craig Aronoff,
Nicholas Galendez,
have a great day, everybody.
See ya.